Hello everybody, I am Sana and in today's video we shall be discussing legal news at a glance. I am the legal expert for Hitbullseye and today's video we shall be discussing January 16 to 31st legal affairs. Basically all the important updates in the span of these 15 days. So let's get into the video and start discussing. The first case that we shall be discussing today is Shriram Chirmakar versus Union of India. Now in this case, the Supreme Court stated that child adopted by a widow after the death of the government employee is not entitled to the family pension. Basically, the facts of this case are as such that a woman who was a widow of a government employee, of an earlier government employee, asked for family pension. Subsequent to the death of the husband, she later adopted a son. The son also asked for the family pension from the government. The government in this regard, the state tribunal, denied any such family pension being given to the son who was adopted after the death of the deceased employee, stating that he was not a part of the family and he was not as such a dependent of the former employee. In this case, basically Shriram Chirmakar, in this case it was alleged that Section 8 to Section 12 of the Hindu Adoption and Maintenance Act, under this, basically, if the husband dies and subsequently the wife or the widow adopts a son or a daughter, then the son or the daughter are considered to be a part of the family of the dead husband. So it will be presumed that they were also the direct son or daughter of the deceased person. However, in this case it was taken that the rules which were applicable in the present scenario were Rule 54, Clause 14B of the Central Services Pension Rules 1972. So here the Supreme Court stressed on this thing that there are two separate statutes or two separate legislations. Here these are rules which are applicable vis-a-vis the government employees, and they are defining the term family so as against the government. And here Section 8 and to Section 12 of the Hindu HAMA, that is Hindu Adoption and Maintenance Act, they are defining the rights and liabilities of the adopted child vis-a-vis the adoptive family and not the government as such. So therefore the government defining the term family cannot be extended to include the person who were not even the dependents of the government servants at the time of his death. Here the Supreme Court stressed on the fact that there should be a certain nexus of the deceased with the person who is asking for such family pension. Here the deceased, the adoptive son was adopted subsequently. He did not even know basically the deceased. He had no nexus with him. He had no familiarity with him. He had no biological connection with him also. The Supreme Court further bifurcated, or the Supreme Court further distinguished a child who is born after the death of the deceased, who comes from the biological parentage of the deceased, and a child who subsequently adopted. The child who's adopted cannot be said to be the son of the deceased. However, the child who is a biological child can take the advantage of such pension as such. In our next case, the Supreme Court further discussed the idea of the last seen theory. The last seen theory, if we talk about, it is an important principle in the Evidence Act. It states basically that if there are two persons who are seen together at some point of time, and the next time when the two people are seen, one of them is dead and one of them stays alive, then a presumption can be taken, or there is a certain evidence against the person who remains alive, so that the onus is on that person to prove or to be able to substantiate what were the circumstances of the death, or what were the circumstances in which he met the person who subsequently died. So, however, it can be seen that it has been taken that it is not a very substantial piece of evidence, and it's a very weak form of evidence, and it just shifts the onus to the person who was last seen with that person who became subsequently the victim of any act. So here, in Jabir versus the state of Uttarakhand, the court stated that the last seen doctrine has limited application, where the time lag between the deceased was seen last with the accused and the time of murder is narrow. So, in this case, the Supreme Court stressed upon the concept that the last seen theory is only applicable in the time where the last seen, where the person being last seen together with the victim is very close to the person, very close to the time when the victim actually died or when the dead body was found. In this particular case, the victim and the accused were seen together early morning 9th of October 1999, and the deceased body was found in the sugarcane field on the 10th of October 1999. So there was as such a gap of almost 2 days, and also in the post-mortem report, when the post-mortem was later conducted, even after 2 days of the dead body being found, then the doctor stated that the time of death could not be properly determined. So therefore, it could not. The time gap of these 2 days was held to be very wide and not narrow at all. And in this case, the lower courts had basically convicted Jabir only on the last seen theory. The Supreme Court in the present case stated that last seen theory was not enough in the present case to convict the accused of the offence, as the time was not narrow at all. In the present case, now let us come to the Supreme Court, Fishermen Care versus Government of Tamil Nadu, Ghana Sekar and others versus Union of India, and other such connected matters. So it's basically a clubbing of special leave petitions, various special leave petitions arising from an interim order of the High Court of Tamil Nadu. In this case, the Supreme Court has basically allowed purse-seine fishing beyond Tamil Nadu territorial waters, but however with certain terms and conditions. In order to discuss this, we shall first try to understand what is purse-seine fishing. So purse-seine fishing, as you can see in this picture, purse-seine fishing is a type or is a method of fishing in which huge nets on huge boats are taken by the fishermen into the sea. These nets are sorry, these nets basically they go very deep. The fishermen leave these nets into the sea, and they go very deep into the sea. Whatever comes in the way of these nets, these are called the purse-seine nets. So whatever comes in the way of these nets, it is caught by the net. So essentially, if we talk about it, fishermen go to fish tuna or certain one particular fish or two particular fishes which are actually sold by them in the market. However, they end up catching all the marine life that is there in that area. So in this net, not only tuna or not only the marketable fish will be caught, but also some endangered species might be caught. Also some turtles, whales, etc. are seen to be caught. And the bigger the animal, the bigger the more impossible it is for them to escape from this net. So we understand that it is a very non-target, non-selective kind of a fishing, a very high throat, a very high mortality kind of a fishing method. So what happens in this case is that it is endangering all the marine life. It was put to, a ban was put to it by the fishing regulation rules, that is the Tamil Nadu Marine Fishing Regulation Rules, Rule 17.7. This was subsequently challenged by certain fishing associations and a number of people, because in their contention they stated that there is only 3-month period that they get to make any living whatsoever. Their living income etc. is anyway very low, and even in this particular season of 3 months, if they are not able to catch proper fish, then their livelihoods are at stake. So the matter was pending in the High Court of Tamil Nadu. However, in the interim order, the High Court of Tamil Nadu had put a ban on the fishing. However, the Supreme Court allowed the purse fishing, but however with certain terms and conditions. And firstly, in interim order, it has allowed it only into the territorial waters of Tamil, not in the territorial waters of Tamil Nadu, but within the exclusive economic zone. If we talk about what is the territorial waters and what is the exclusive economic zone, we shall see that if we calculate from the baseline, 12 nautical miles is the territorial water. In this, Persian fishing is not allowed, and in the 200 nautical miles beyond the territorial sea, the Persian fishing is allowed. Now, what are the terms and conditions under which Persian fishing is allowed? Firstly, only registered vehicles can do Persian fishing, and not just any boats and vehicles or vessels. Color coded vessels should be there. One particular color is going to be allotted by the state government, and only the boats would be required to be in that particular color, so that the boat can be identified from afar also. Vessels will have installed vessel tracking system, and it can only be done twice in a week, that is only on Mondays to Thursdays, and also from 8 a.m. to 6 p.m. not before 8 a.m. and not after 6 p.m. So they have limited their time essentially so as to limit the number of fish that are, or the marine life that is caught by Persian fishing. And the last condition is that the sailors shall be required to carry IDs at all times when they are fishing. And not just IDs, they are also supposed to carry some kind of biometrics also, so that it can be identified that the people who have the license or who have the permit to fish as such are doing it, and nobody else. In our next case, Berul Islam and others versus Indian Medical Association, the Supreme Court ruled that people living in the rural areas must not be shortchanged by the state's policies for enhancing access to rural healthcare. In this case, basically, the constitutional validity or the validity of Assam Rural Health Regulatory Authority Act of 2004 was put under question vis-a-vis the Indian Medical Association Act of 1956. Here, the Supreme Court stated that any variation in the standards of qualification required of medical practitioner who render services in rural areas vis-a-vis those rendering services in urban and metropolitan areas is violative of constitutional rights of substantive equality and non-discrimination. If you have to understand a little bit about this case, the Assam Rules Health Regulatory Authority Act, it allowed certain activities to be performed by certain persons who were not doctors but who were only diploma holders. So there were certain things such as medicine and rural health care to treat certain common diseases, to perform minor procedures and prescribe certain drugs as such. So these procedures could be carried out even by the diploma holders also. The idea behind promulgating these kind of rules was essentially to increase the accessibility of medicine in rural areas as well. However, the Supreme Court stated that according to Article 47 of the Constitution of India, it is not only accessibility of public health care, but the goal is highest attainable standards of physical and mental health. So you have to not only provide certain kind of healthcare, you have to provide the best kind of healthcare that the state can provide. So in order to provide that, we cannot compromise with Article 14 of the Constitution. That is, we cannot have different standards for doctors in the cities, and we cannot have different standards or substandard or lower standards of doctors or medical practitioner in the rural areas. Therefore, this rule or this particular the certain particular rules under this act were held to be uh, violative of Article 14 and violative vis-a-vis the Indian Medical Council Act of 1956. In the last case, the Supreme Court stated, don't record witness testimonies in English translations alone. So it basically, in this particular case, Justice Bela M. Trivedi has emphasized categorically for the trial courts to record all the testimonies of the witnesses strictly in the language as per section 277 of the Code of Criminal Procedure. What the Code of Criminal Procedure states in this regard is that whenever a judge is to record the testimony of a certain person, if the testimony is in itself in the language of the court, the language of the court is basically decided by the state itself. So the state is going to decide the language of the court, and if the person who is giving the testimony, who is a witness, is giving this testimony in the court in the language of the court only, then there shall be no problem, and it shall be recorded as such in the way and manner he spoke. The next is, if the testimony is in another language other than the language of the court, then a true translation will be readied by the judge, and the translation is going to be, the translation firstly, it is not going to be in English. The translation is again going to be in the language of the court only. The translation will be readied and it will be put with the testimony of the witness. And if the testimony is in English, then it is not required. The testimony, if it is itself in English, then it is not required to be translated further. The reason that Justice Bela M. Trivedi and Justice Ajay Rastogi gave in this regard was that whenever a witness is giving a certain kind of testimony, the kind of words that he uses, the kind of pauses that he takes, everything, they mark basically the tenor and the demeanor of the witness. So when this evidence is going to be appreciated in a higher court, then it is going to be much more easy for the appellate courts to assess or to appreciate the evidence if it is read in the same way in which the witness gave that evidence in the first place. So that is all with the updates of this video. We shall be back in the next week with some other topic of law. So kindly stay tuned and thank you. Have a nice